Okay. Good morning and welcome to today's webinar. We're going to cover what to do when an application to suspend the warrant is received. My name's Laura Hanson and I'm a Senior Associate Solicitor in the Housing Litigation team, and I deal with all housing management issues and tenancy enforcement and antisocial behaviour. Today I'm going to discuss what to do when an application to suspend the warrant is received. And just a bit of housekeeping, the copies of the slides will be sent out after the session, and a recording of the webinar as well, so that you can refer back if you need to at a later date. So today's webinar is going to cover a quick recap of warrants of possession, when you can apply for a warrant, permission of the court, etc. And basically we'll recap all the steps required before an application to suspend the warrant is made. We'll also cover the court's powers to suspend a warrant, how to apply to suspend the warrant, factors the court will consider, what will happen if the warrant is suspended, and what happens if the warrant is not suspended. I've put my contact details on the slide, so if you have any queries or questions that come to you after the session, please feel free to drop me an email or give me a call. But there is a Q&A box, so also feel free to put a question in there throughout the session if anything does come to mind, or you can wait till the end if you'd prefer. So you'll see on the slide I've just put a brief overview of possession proceedings right through from the notice of seeking possession through to eviction. And you'll see that the stages are basically notice of seeking possession, issuing possession proceedings, the initial hearing, a trial, in some circumstances, requesting the warrant, and eviction. And this is the part that we're concentrating on today. So just a quick recap as to what a warrant of possession is and what it means. A warrant of possession is used to enforce the possession order, and this means that if a tenant or occupant doesn't leave the property when the court bailiffs have the power to evict them. When can a landlord apply for a warrant? The landlord can enforce a possession order by asking the court to issue the warrant of possession, and it can be issued if the tenant doesn't leave the property on a date set out in an outright order for possession, or if a tenant has breached the terms of a suspended possession order. A warrant cannot be issued before the possession date on the order though, so you do have to wait until expiry of that date before you can then request the warrant. So how to request the warrant? An application for a warrant is made on the form N325, and this is submitted to the county court where the possession order was made. The application is made without notice to the tenant, so you don't need to let them know that you're going to be requesting the warrant. You can just do this with the courts. There is also another form, the N325A, if the tenant has breached a suspended possession order made in relation to rent arrears. And where the possession claim was made online, if you're requesting the warrant yourselves in-house, you can also use the PCOL system to apply for the warrant. So just for reference, I've included what both forms look like. First of all, we have the N325 and then the N325A. Don't worry if you can't read the small print on the slide, you can actually access these documents in an amendable format on the gov.uk website. It's just to give you an idea, if you haven't already seen them, what they look like. So a landlord doesn't usually need to apply for permission of the court to request that a warrant is issued, but there are some circumstances when the court's permission is required. So those would be where the order was suspended on terms other than the non-payment of rent. So for example, in cases of antisocial behaviour, if those are the suspended terms, you would then need the court's permission to enforce the warrant. You also need the court's permission if 6 or more years have elapsed since the possession order has been made. However, at that stage, it would be advisable to seek legal advice because it may well be worth starting the possession proceedings again rather than seeking permission to enforce that warrant. So if you do have a possession order that has expired after 6 years, I'd probably suggest seeking advice before trying to get the court's permission to request the warrant. If the possession order was made against a trespasser and the application for the issue of the warrant is made more than 3 months after the date of the possession order, you also need the court's permission. Also, where there has been a change in the parties entitled to enforce the order, so for example by a death or otherwise, then you will need the court's permission. And also if there has been a death and the warrant is sought against the executors or administrators, those are sort of the anomalies really. You more often than not, if it's a straightforward rent case, you don't need the court's permission. But for example, if it's an antisocial behaviour case, you will need the court's permission for breach of the suspended order. So to apply for permission in any of those circumstances I've just discussed, you'll need to use the form N244, which is the general court application form. And then once the court grants permission, you then need to go back to the original request for warrant form, which is the N325 we've also just looked at. Permission can be granted without a court hearing. However, some courts do still seem to list for a hearing even though they don't need to. It just depends on the court or the judge dealing with the request. So there's no requirement for you to give notice to the tenant of an application for a warrant of possession or permission of the court. So you don't need to let the tenant know that you're doing that unless there is something stipulated within the order that says that you need to let them know. Just got a question. Let me just have a quick look. So the question says, can you require permission to enforce a warrant suspension order, or do you always need to enforce the original SPO? I think what you're asking is, if you're asking, do you always need to enforce the original SPO? It's in the first instance, if it's the first breach of SPO, then you will be seeking to enforce that order. If you then get a suspended warrant, you would then be asking for, you sort of then a step further ahead. So you would then be asking the court to enforce the suspended warrant, if that makes sense. There's another question. Do we know how long a warrant suspension lasts? That I will be covering that, but it is 12 months. So whereas your SPO is, or your possession order lasts for 6 years, the warrant suspension is only for 12 months. So it's worth bearing that in mind. That can be quite often something that you will consider if you have an application to suspend the warrant and you're deciding how to deal with that. Sometimes it might be beneficial to agree a new SPO rather than agreeing a suspended warrant, because the new SPO would give you longer to enforce that, whereas agreeing to suspend the warrant would only give you 12 months. So I hope that answers those questions. If not, do feel free to drop me an email and I can have a look at that after the session for you. So I've covered notice to the tenant. You don't need to give notice unless the court directs otherwise. Oops. Okay, so there are just a few important points to note when requesting the warrant. Failure to follow the correct procedure may result in the warrant being refused. As we have discussed, the warrant is valid for 12 months. And you can't apply for the warrant during a breathing space moratorium as well. So you would just have to check the individual circumstances of the case. Okay, so the notice of eviction, the bailiffs must deliver a notice of eviction to the premises at least 14 days before the eviction is due to take place. This will be on the form N54. You don't need to worry about that. That's the form that the bailiffs actually complete and send to the tenant. And it will be also covering any other occupiers at the property. The form that provides the notice to the tenant will give details of the date and the time to when the eviction will take place if they don't leave before then. And it will also explain that an application to suspend the warrant can be made. So it sort of gives them a bit more information how to do that. The court can actually dispense with the requirement to serve the notice of eviction 14 days before the date of eviction, or they can agree to shorten the time for it to be delivered. So we've had cases where the court has agreed that it can be done within 7 days rather than the 14. It will just depend on the circumstances of the case. And the requirement to deliver a notice of eviction doesn't apply where the action is taken against trespassers who have never had permission to enter or occupy the premises. It's just for somebody who has been a tenant. So, execution of a warrant by the bailiff. The bailiffs will attend the property at the time stated on the N54, and the landlord or a representative is also usually present. In cases where there is antisocial behaviour or potential risk to anybody during the eviction, sometimes police presence will be requested, but that again is also on a case-by-case basis. And if that's going to be the case, you also need to advise the court and the bailiffs in advance that you will be requesting police attendance. You might have been asked to complete a risk assessment form with your request for the warrant. That again just sort of gives a bit more information to the bailiff as to who they're likely to encounter when they do attend the property. And when they do actually execute the warrant, the bailiffs can evict anyone they find on the premises, including any occupiers who were not a party to the original proceedings. I think I've just got another question. Let's have a look. So somebody's asked, how do you apply to accelerate the 14 days to 7 days? In cases where we've done this previously, we've done it where an application to suspend the warrant has been made, but where we were asking for that application to be dismissed and for the warrant for eviction to go ahead, but for that to be at 7 days rather than the 14 days. If you're doing it at the application for the warrant stage, I would suggest you'd put that as part of your application within your cover letter, or just put an additional letter up within your request outlining the reasons why you need it to be sooner. It would just depend on the courts. They may turn around and say that you need to make a formal application to do that. Usually it would probably be done at an application to suspend the warrant hearing, where you're asking for the warrant to be enforced and their application to be dismissed, and you still want it to go ahead within a quicker time frame. So it is a possibility. I would say it's not the norm to do that though. So I hope that answers your question. Sorry, the slides are just taking a minute to catch up. Okay, so an application to suspend the warrant. So now we're getting to the tenant's application to suspend the warrant before the eviction takes place. The court has the power to suspend a warrant if the grounds for possession were made, if the possession order, was made on discretionary grounds. The court's powers are more limited where the possession order was made on mandatory grounds, for example, following a Section 21 notice. An application to suspend the warrant is made on the N244 form. So obviously this is something that would be done by the tenant or their representative or somebody assisting them, and they would need to submit their application to the county court where the possession order was made. They can also do it via the PCOL online system, which usually they need to do with at least 5 days notice, but as I'm sure you're aware, it does tend to happen last minute, and the courts will allow that, particularly if somebody is at risk of becoming homeless. They're quite often last minute applications the day before or even the day of an eviction. And once an application to suspend the warrant has been made, there will be a hearing listed with a district judge before that eviction is due to take place. Just got another question. Oh, sorry, I was just no, we're okay. So the content of a tenant's application to suspend the warrant, I've just put on the slide a copy of the N244. I'm sure you've probably seen this before, but if you're presented with one, at least you know what to recognise. This would be the form that they're asking the court to suspend the warrant, and it would be accompanied by a witness statement. I've just put a precedent version on screen as to what that may look like, but they do need to have the support of a witness statement. The N244 form is available on the gov.uk website along with guidance notes as to how to complete it. So if you're asked where this can be found on behalf of a tenant, you can refer them to the website, and it does have guidance notes for them. Or they can contact the court, who will be able to provide a paper copy. Don't worry about being able to read the small print of the form, but basically the form asks for the court details and the claim number and the warrant number, just so that the court can locate the paperwork easily. And this can all be found on the notice provided by the bailiffs. The application contains a statement of truth, and this is where the tenant's confirming that they have an honest belief in its facts. And as I've said, the application must also include a witness statement to provide the court with the facts of the case. And this is the best way for a tenant to set out what they want the court to consider. A witness statement by the tenant must be in a specific format. So that's the format that I've shown you is the sort of the start of the statement, and that's in compliance with the civil procedure rules. Quite often, if tenants are doing these applications themselves, they're not going to be following the correct format. However, the courts are sort of understanding of a litigant in person, but really it does need to be in the format as shown on the screen. It needs to be written in the tenant's own words, and it will include specific case information, details of the property, etc., and it's signed by a statement of truth. I think just check for a question on that point. So somebody has asked what the limited powers are for mandatory grounds, and it is off the top of my head, I'm not sure if I'm covering this later in the slides, and if I'm not, I apologise, and I will come back to you on that. But it is more of a case that the court can suspend the warrant for a short period of time, rather than the sort of on discretionary grounds. The court has more power to suspend for on other grounds. Sort of you can ask the court for terms as similar terms that you would have in your SPO, so it compliance with the tenancy and things like that. The court may not have those powers when it is a mandatory ground. When we cover the rest of the slides, if I haven't addressed exactly that point, please do let me know, and I'll come back to you after the session with that point. Okay, so that covers the content of the app to suspend. So as part of the application to suspend the warrant, the tenant must explain why they want the warrant to be suspended, and they can set out their reasons within their statement. Sometimes they do set those out within the N244, which again, as I've said, the courts are sort of quite lenient in that respect. When the application is made, it may be that if we get to a hearing, we would then be asking them to put that into a proper civil statement format. But just for the purposes of their initial act to suspend, they just need to set out their reasons. And if they've breached a suspended possession order, for example, on rent arrears grounds, they'd need to explain why they've breached the order and what they can do to prevent further breaches and how they can afford to pay something towards the arrears as well as their contractual rent. So they would need to make sure they're addressing all of those issues within their application. If they've had debt or benefits advice, they should also refer to this when explaining what they can do to avoid breaching the order again. So it's advisable that they do put all of that information in their apt to suspend. The tenant can ask the court to adjourn the application or stay the warrant if there'll be a change in their circumstances. For example, if there's a problem or delay in receiving the benefits they're entitled to, or if their financial circumstances are changing. For example, they're getting a new job and then they're likely to receive regular payments after that. They should also provide clear evidence of any of these change of circumstances. For example, they would need to provide a letter with a start date from an employer for a new job. They should also include any other relevant factors, and you'll quite often see this where they will say that they've got a health condition that's prevented them from taking steps to resolve the situation. So they should explain anything that means that experience exceptional hardship if they were to be evicted. So, for example, the property has been adapted because the tenant has a disability. Therefore, if they're evicted, they're going to experience exceptional hardship. Finally, the tenant should include evidence to show how they can afford to offer to repay the arrears. And again, this can be a financial statement. If the tenant has had debt advice, that would be something that has been discussed with them and provided to the court, that they can afford to pay X amount. Next slide. So when submitting the application to suspend the warrant, it should be made with at least 3 days notice. So if your eviction is on the Friday, the act to suspend needs to be made with at least 3 days notice prior to that. However, as I've said, in practice, a tenant can apply to suspend the warrant anytime up to and including the eviction date. It's usually a very last minute application, and an urgent last minute hearing is often listed. The tenant should submit their application form as well as a copy for each party, and one for the court. So they need to submit copies of that when making the application, although the court will probably do that for them if they just turn up to court with one copy. The court does have the power to agree to a shorter notice period other than the 3 days, as I've said, which will quite often happen in practice. The court sometimes temporarily stays the warrant pending the hearing if the court doesn't have capacity to list the hearing before the warrant is due to be executed. So if the court's lists are just too chocker and they can't get an urgent hearing in before the eviction date and time, they may just temporarily stay the warrant and then deal with it after that date. But usually the courts will fit the hearing in before the eviction, even if it is very last minute. So the court will set a date for the hearing to decide the application, and both parties should attend. I have had it before where a tenant has made an act to suspend and then they don't bother to attend their own application hearing, and in those circumstances you would just ask for their application to be dismissed and the eviction to take place as planned. I'm not sure why they wouldn't necessarily attend their own application, but it does happen. So if you do have a hearing date for an act to suspend, make sure you attend or ask a representative to attend so that you can ask for it to be dismissed in those circumstances, or even that may be your primary position anyway, that you're asking for it to be dismissed, regardless as to whether they're attending or not. The court can decide not to have a hearing if, for example, discussions have taken place between the parties and a consent order is agreed prior to a hearing. That can happen, but more often than not, it will be an attended hearing. So we're now going to look at what the court will consider. The court can look at a broad range of factors when deciding whether they should suspend the warrant. And these factors will include that the tenant's going to lose their home. The court will consider the responsibilities of social landlords to other tenants, the nature and seriousness of any breaches of the tenancy agreement, and the nature and seriousness of any breaches of the possession order. Where there's a substantial dispute about the amount of rent arrears, the tenant should ask for the application to be adjourned and the warrant stayed until this can be established. So this would be if they don't agree with the figure that, say, you've provided in the rent statement for whatever reason. So it may be that a hearing will be adjourned just for clarification on that point. The tenant may also try and raise a defence based on a breach of their human rights. And the county court will only allow this to be heard in exceptional circumstances. So the court does have the power to consider breaches of tenancy other than those relating to the grounds in the original possession claim. So, for example, if you have made if you've obtained a possession order solely on rent grounds, the court does have the power to consider additional antisocial behaviour at a hearing for an act to suspend. And this can be used to your advantage as to why their application should be dismissed. This is in accordance with case law of Sheffield and Hopkins and Manchester and Finn, which you may have heard of. So that means you can add additional grounds. So, for example, grounds 12 and 14 to an order that is just based solely upon, say, grounds 10 and 11. In deciding whether to allow new grounds, the court can take into account the policy of the legislation, which is to only evict after a serious breach where it is reasonable to do so, that it may not be possible to deal with wider issues on an application to suspend, whether the landlord included the allegations in the original proceedings. So the question may be asked, well, why wasn't this included from the outset? And we would have to be able to provide evidence as to why that hasn't been included. Sometimes the antisocial behaviour, for example, has started after the possession order was made, and that would be a valid reason why it wasn't all included together. And the tenant should have been given evidence of the allegations, especially if they're not provided within the original proceedings. So if you have an order on rent grounds, but you suddenly receive complaints of antisocial behaviour, it is worth putting that into witness statement format so that you have it to hand at an act to suspend to say, this is the evidence we've received, rather than it sort of just being mentioned at the hearing and then expecting the court to use that as additional grounds. So it's certainly beneficial to be collating any evidence that you receive like that into a witness statement format, just in case you do want to add those as additional grounds. So in terms of the court's powers, the court has broad powers to suspend the warrant if the tenancy is a secure tenancy, assured or a short hold tenancy, and the possession order was made on a discretionary ground, as I mentioned earlier. The court also has the power to stay the execution of a warrant if the tenant is unable to pay any payments set out in a possession order. A stay of execution delays the enforcement of a court order, either to a fixed date or until a specified event has occurred. And the court can decide on what terms and how long the warrant is stayed. So this would be where until the specified event has occurred. If the tenant is able to make a payment at a certain date and time, a court may stay the execution until that payment has been made. That is what that part is covering there. If the court didn't have discretion in making a possession order, the court's power to suspend the warrant is limited. This includes if the order was made on a mandatory ground, for example, ground 8 for assured tenants, or under section 21 against an assured short-hold tenant, or against an occupier with basic protection. This is hopefully going to cover the question that was asked previously about the powers when the mandatory grounds are used as a possession order, and the court can only delay execution in these cases up to 14 days after the date the possession order was made, or 6 weeks in cases of exceptional hardship. If the tenant is in a breathing space moratorium or mental health crisis moratorium, the court must ensure that any proceedings to enforce an order relating to a moratorium debt do not progress. So always check the circumstances of a case just to ensure that there isn't a breathing space there. This would also include a warrant of possession if the order was made in relation to rent arrears, and it applies even if the order was made on a mandatory ground. The landlord must notify the court when a breathing space starts if proceedings were already underway, including if a warrant has been applied for. So again, just if there is a breathing space, the court needs to be advised of that. So when the court grants the application to suspend the warrant, the bailiffs will be informed and the warrant will not be executed. If the warrant is due to be executed, the tenant should contact the bailiff's office to let them know it's been suspended. However, the tenant can make another application to suspend the warrant if they breach the terms of the suspension. So if their application has been approved by the court and the warrant will not be executed, it may be on further terms that they need to comply with. If they breach those terms and another request for the warrant is made, they can then make another act to suspend. So you may have had cases where you've had act to suspend after act to suspend. That can happen. I've had them previously where we were up to 6 act to suspends. The court might take into account previous breaches when deciding if it should suspend the warrant again. And the tenant will still need to explain a change in circumstances that means they won't breach the terms again. So they will need to be explaining to the court why the warrant should be suspended. If you're getting down the line where you've had a couple of suspensions, what's changed, and they need to provide evidence to the court of that. Just a question. Just bear with me, I'll just have a look at this question and see if it's something that I can address now, or if it's something I need to come back to you on. So somebody has asked if we can have the slides. Yes, you can have the slides. And somebody else has asked, when a stay application has been dismissed, but there are still a few days until the eviction date, is our only option to stop another stay application being lodged and a hearing not being scheduled for us to ask the tenant to seek the court's permission to submit another stay application? We've had cases where an application was made every day for approximately 3 days, and a lot of time and resource was spent to keep attending hearings, as the court said they have to put it in front of a district judge. So the court is correct. They do need to put the application before a district judge. In this case, it is extremely frustrating that if you've had the application has been made well in advance of the eviction, and that has enabled them to make subsequent applications. Of course, it will depend on the circumstances of the case, but it may be that you ask the court to order that no further applications to suspend can be made, but it's difficult to advise, just generally speaking. So if whoever's sent this question in wants to drop me an email, I might be able to provide a bit more specific advice. But if you're attending an eviction hearing, an apt to suspend hearing after 3 other hearings before that warrant date is executed, you would then be asking the court, can they order that no further apts to suspend are made? As I've said, it will depend on the circumstances of the case, and it's at the court's discretion. It would just depend what is happening within those within the space of those applications, and if anything has changed or not. It's very difficult to advise, generally speaking, but you could try asking the court to put something in order to stop any further applications being made. Just bear with me. So if the, oops, just bear with me, my slides have just stopped again. Okay, so if the warrant is not suspended, the bailiffs will carry out the eviction on the date given if the court does not grant the application. So the tenant's made an application to suspend the warrant, the court dismisses their application, then the bailiffs can carry out the eviction as originally agreed with the date due for execution of the warrant. The tenant can appeal the judge's decision not to suspend the warrant. An appeal would usually be heard by a circuit judge. And if a tenant is appealing, they should request a stay of execution of the warrant until the appeal is heard. But they can only request an appeal in certain circumstances. And again, it's up to the judge whether they're going to allow for an appeal. But usually if the court dismisses the application, the eviction will then go ahead. So where a tenant's circumstances have changed, they can make a fresh application to suspend the warrant, and the tenant cannot make the application without a change of circumstances. So as I was just answering the previous question where subsequent applications have been made, I would presume, without knowing the facts of the case, that the tenant is asserting that there has been a change in circumstances, and that's why they're now making a fresh application. If the case is that the position remains the same, then you would be entitled to attend that hearing and say there's no change in circumstances, and therefore the application should be dismissed and there should be no further applications allowed to be made before that eviction date. The court has no power to suspend the warrant after it has been executed. So after the eviction date and time has taken place, the court can't then retrospectively suspend a warrant. However, a tenant may be able to apply to set the warrant aside if there's been an abusive process. But again, that's not really something that would usually happen. It's just being aware that that is a possibility. So if in doubt, seek legal advice. If you've had a few apt to suspend hearings and you're not sure where to go to next, or you're not sure why the court is continuing to allow the applications, then do feel free to seek advice and we can assist further, or we can attend the hearings on your behalf. I've put my details on the slide, so as I've said earlier, please feel free to contact me if you do have any questions that aren't really generic questions that I can answer during the training session. I'm happy to discuss things after the session. You will also receive copies of the slides and a copy of the recording. It will be sent out to everybody who registered on the session. So if any colleagues weren't able to attend, they can still watch the session back. And we do have some further training sessions coming up. We have monthly webinars. Details of the next webinars are up on the screen, and you'll be sent links to attend those webinars as well. I'll just check for any final questions before we finish the session. What happens if a dog has been left in the property? Is it the responsibility of the landlord to ensure the dog is safe and cover the cost of kennel charges? I would probably need some further information in respect of that query. Whoever sent it in, if you drop me an email with your query, I'll be able to come back to you because I probably just need to ask you a bit more information and just check whether the tenant has made any arrangements, or if they have just literally abandoned the pet in the property, have the RSPCA been informed and things. If you just drop me an email, I'll be able to come back to you when I've got a bit more information from you. So that's the end of today's session. If there are any further questions, please do give me a call or drop me an email, but I hope you found that useful. Thank you. Bye bye.